All right. Good afternoon, everyone. I would like to call to order this public hearing, the Committee on the Judiciary of Public Safety. The time is now 2:09 p.m. on Wednesday, May 17th, 2023. We are conducting this roundtable virtually and streaming on the DC Council website and YouTube at CM Brooke Pinto. I am Councilmember Brooke Pinto, representing Ward 2 and chairwoman of this committee. The purpose of today's hearing is to discuss the following two bills. First, Bill 25-41, the Forbid Lewd Activity and Sexual Harassment, otherwise known as the FLASH Act of 2023. And Bill 25-51, the District of Columbia Crime Victimization Survey Act of 2023. The Forbid Lewd Activity and Sexual Harassment Act of 2023, or the FLASH Act, would establish a private right of action against a person who sends an obscene, unsolicited image by electronic or other means. Under the FLASH Act, individuals who engage in cyber flashing risk penalties that include economic and non-economic damages, statutory damages of not less than $500 but not more than $1,500, punitive damages, reasonable attorney's fees and costs, and any other relief, including injunctive relief. A 2018 study by the dating and social networking app Bumble found that nearly 1 in 3 women have received unsolicited lewd photos from someone they had not met in person. By March of 2022, that figure had climbed to nearly half of all women, with nearly 1 in 3 respondents specifically saying that they had received a lewd photograph in the last month. Since Congress has failed to pass meaningful protections to keep people, especially women and members of the LGBTQIA+ community who are disproportionately targeted, safe on the internet, states and the District of Columbia have to step in to try to address many of these gaps. We have already taken steps to address revenge porn online, and creating a private right of action against people who commit cyber flashing is an important next step. While there have been laws in the books prohibiting indecent exposure in person, for decades, we've seen similar activity now that takes place on the internet, and it's continued with impunity. I look forward to hearing directly from our public witnesses today about the impact that online sexual harassment, including cyber flashing, has on victims, and how the option to seek a private right of action against perpetrators will improve their safety online. My team and I have worked closely with the dating app Bumble on this bill. They have advocated for and been successful in getting similar bills passed in Virginia, California, and Texas. The FLASH Act closely aligns with the penalties that are outlined in Virginia's legislation, and that is by design as part of our goal to have consistent penalties across the region. I hope that Maryland will also join us in this effort, and that the progress that we make in the region will inspire other states to pass similar legislation. I think consistency is especially important here in our region, given our transportation system and how many people come in and across state lines every day. Second, we will discuss the District of Columbia Crime Victimization Survey Act of 2023, which will require the Office of Victim Services and Justice Grants to contract with an entity to conduct a biennial crime victimization survey. The survey will collect data on criminal victimization incidents experienced by respondents within the last 12 months, and whether they reported the incident to police, their experience with the police if they did report the incident, and if they did not, the reason that they chose not to report the incident. The survey will also collect data on any actions taken by the survey respondent after the incident to address the consequences of victimization, including alterations in behavior or the respondent's physical environment. This survey will provide the district government and victim service providers with a more accurate picture of the state of victimization in the district that is not fully represented in police reports or in data from victim service providers that we currently have available. This data will inform how we can better serve victims of crime and where additional resources are needed for continued support. This bill was first introduced by Chairman Mendelson and Councilmember Allen in July of 2022, and a hearing was held on December 8th, 2022, when Councilmember Allen was the chair of this committee. Several witnesses testified then about the need for service providers to be involved in crafting the survey to ensure the questions prioritize harm reduction and are culturally competent. Witnesses also expressed a need for language access and transparency in the data collection methods to ensure that marginalized communities are included. There was also a discussion of the importance of more clearly defining the goals of the survey to ensure that the contractor is given clear guidance in how the survey should be structured. I look forward to diving into these questions more today as the new chair of the committee and exploring how the language of this bill can be strengthened to address these concerns. For today's hearing, we will hear first from the public witnesses here to discuss the Flash Act. Then we will hear from our government witness on the bill. Third, we will hear from the public witnesses on the Crime Victimization Survey Act. As always, public witnesses will have 3 minutes to present their testimony, and those who represent organizations will have 5 minutes. So first, I would like to call our first panel of public witnesses in the Flash Act. Patrice Sultan, Executive Director of the DC Justice Lab, Donna Lent, National Women's Political Caucus, Peyton Ehem, Global Public Policy from Bumble, Inc., Christian Nunez, President of the National Organization for Women, and Santiago Lacatos, ANC Commissioner from ANC 1B04. If you are all ready, Patrice Sultan, please go ahead.
Good afternoon. Thank you, Chairwoman Pinto, for the opportunity to be heard. My name is Patrice Sultan, and I'm the founder and executive director of DC Justice Lab. There are over 100,000 lawyers licensed in the District of Columbia. Most of them could have told you that this bill is unconstitutional. It is important that when you write a law that punishes someone with statutory damages, or when you write a law that restricts a fundamental freedom like speech, it is done with care. This bill illustrates that the council's good enough for introduction standard has fallen incredibly low. I provided a lot of examples in my written testimony, ranging from Romeo and Juliet to Rihanna, but I'll start with this one. Suppose I take my friends to a DC strip club and we record videos that capture nude women in sexual and sexualized poses. So this is something that happens every night of the week in the district. If I then send my video to my friends in a group text or post it to my Instagram stories, I would incur no less than $500 in statutory damages for every person who receives it on their phone, even if every one of those people was in the strip club with me. This example illustrates the two biggest problems with how this bill was written. First, it defines obscene image to mostly include images that are not obscene in the constitutional sense of the word. A picture of someone's genitalia, which I think is the subject of this bill, is not patently offensive under Miller. And second, it fails to define unsolicited, leaving it to be interpreted literally, as in without someone soliciting it first. That is much different than, say, without effective consent. Defining consent was one of the hardest aspects of revising the DC Criminal Code. The American Law Institute has been struggling with it for years. It is extremely difficult to get it right. And more importantly, this council, which sits in the nation's capital, ought to be very careful about requiring someone to consent to speech. The Criminal Code Reform Commission drafted recommendations about obscenity laws. Those recommendations were drafted with clarity and precision. They include definitions and mental states and exclusions and defenses, and no one seems to have consulted the commission or the hundreds of pages we wrote. No one also seems to have considered that we already have liability for things like intentional infliction of emotional distress, negligent infliction of emotional distress, and stalking that cover the most egregious forms of the harassment that this bill targets. I explained in my written testimony that attaching penalties to this kind of speech could also have the unintended consequences for victims of serious crimes. We wouldn't want someone who is being trafficked to have to worry about coming forward because they posted a nude on a sex work site. The first time I heard of a bill like this was about 5 years ago when New York had a problem with men airdropping photos of their penises to unsuspecting women on the subway. That bill was rightfully rejected, and Apple changed its technology to let users control who can send them content by airdrop. Today, we have Bumble here advocating for this bill. Someone should ask them why, instead of infringing on the liberty interests in a city where they are not based, they don't simply update their technology to protect users of their dating app from unsolicited graphic content. It would be easy enough to use AI to detect images that might be nudes and require approval before those messages are delivered. Global Tel-Link does that for every text, photo, and video message that is sent. The reason that a lot of people would stop using the app. Many people like sending and receiving that content. They don't want to have to ask someone to send it to them, and they don't want to have to ask permission before sending it to others. A lot of people are into that, and it shouldn't be banned just because the sponsors of this bill are not. Lastly, I'd be remiss if I didn't mention that obscenity laws are and always have been homophobic, and reading the history of enforcement of laws like this should be reason enough to vote against it. I look forward to answering any questions you may have.
Thank you very much, Ms. Sultan. I certainly will have some questions for you. Thank you for your testimony. Next, we will hear from Donna Lent from the National Women's Political Caucus. Ms. Lent, you're still on mute.
Thank you. Thank you for holding this hearing today. Yes, I am the president of the National Women's Political Caucus, and our headquarters are located on Connecticut Avenue, right here in DC. The National Women's Political Caucus is the oldest grassroots bipartisan organization dedicated to increasing women's participation in the political process. For 52 years, we have identified, recruited, trained, and supported women for election and appointment to public office. We have worked for the expansion of dependent care and for the ratification of the Equal Rights Amendment. I'd like to thank you, Councilwoman Brooke Pinto, and the other sponsors of this bill for this hearing today and the opportunity to speak in support of B25-41, the Forbid Lewd Activity and Sexual Harassment Act of 2023, also being called the Flash Act. Cyber flashing disproportionately affects women, with recent research suggesting that 48% of all women aged 18 to 24 have been sent an unsolicited sexual image in the last year alone. But men also fall victim. It doesn't matter how old you are. Anyone in close proximity to you can make you a victim. Anyone who has a cell phone number that can be found in the public domain can be a victim. Advertising your professional services, such as a realtor using your cell phone number, can make you a victim. Sitting at an airport, you too can be a victim. Advertising for an apartment, well, guess what? You too can be a victim. Posting your cell phone number on a community wall at a supermarket to sell your car or for babysitting services or house cleaning, you too can become a victim. Part of a large group visiting Disney World? Well, I've spoken to a woman who said she was a victim as her group had agreed to share photos of the day's activities, and a stranger decided to get in on the fun and send her a stored obscene photo. These flashes aren't happening always at the moment the lewd photos are sent. They are lewd photos that are stored in the photos folder on their cell phone, just waiting for someone to victimize. Cyber flashing infringes on women's sexual autonomy, privacy, personal safety, and their right to live free from harassment. Lewd photos leave a lasting impact on victims, their mental health, and feeling of physical safety. The National Women's Political Caucus has worked on legislation in several states to prohibit unsolicited lewd photos. As a result, cyber flashing is now prohibited in states such as Texas, Virginia, California, but laws remain unclear in the majority of states and territories across the United States. The ideal would be to have a federal law that would make cyber flashing an offense. Every time another legislative body, such as this DC Council, takes up the issue, it demonstrates the broad national need for such legislation. National Women's Political Caucus would like to thank all the sponsors of the bill and hope that you will pass B25-41, the Forbid Lewd Activity and Sexual Harassment Act of 2023, also known as the Flash Act, to protect those being impacted by this issue. Thank you for the opportunity to speak today.
Thank you so much for your testimony and the work that you do, and we'll come back to you with some questions. Next, we will hear from Peyton Ehim, Global Public Policy from Bumble Inc.
Thank you. And thank you all for your attention to this issue and also allowing us the opportunity to speak on this issue and in support of the Flash Act. My name is Peyton Ehimi. I am based in the DC area. I'm the Vice President of Global Public Policy, as stated. My focus at the company is working on advocacy and specifically in women's spaces. A little bit about Bumble, because I think it's germane to the topic that we're discussing here. It was founded in 2014, but it was founded specifically by women and for women. And it was to address the toxicity and lack of equity among relationships and online. It was specifically focused on addressing the misogyny that was being seen online. We're most known as a dating app, but at least not forget that we're also well used as a friending, platonic relationship app and business networking app. Many realtors and others use it. People who are new to communities use it. So it's beyond dating. I wanted to address that because this issue is not about dating apps. This is an internet issue. This is something that is much more broad than just something that's happening on one particular app. This is something that's going across on metros, airplanes, and public sectors, and every type of communication you can think about, including networking sites. To the point, Private Detector is something that we have called at Bumble. It's a technology. It's actually artificial intelligence. We created that in 2019 for our own app. It uses artificial intelligence to immediately block lewd images. So it's not all images. It's lewd images. And on our app, it allows you to say yes if you want to see it and no if you don't, because consent is a right. The reason why this is important is that we've solved this on Bumble. So we're not here advocating for a solve for our app or our business. What we're doing is taking our learnings from having a majority women-founded company, but majority of our users are women, of them letting us know what they're seeing on the internet and what they're experiencing. The statistics were provided by others previously, so I won't go over those. Our big interest here is just to make sure that the technology is addressing bad actors. It is very difficult to outrun bad actors with technology, and that's why this bill is so important. We have worked with many advocacy groups, and Grindr, which supports the LGBTQ community, is not opposed and is also in support of our bill. We take that and that community very seriously. And it's not a homogenous community. People choose to communicate how they would like, but in this place, we're thinking consent is what's most important. We've seen these bills passed in other states, as was mentioned, California, Texas, and Virginia just last year. I want to highlight the council members' flag of the importance of making sure this is passed among all of the metro line, because it only takes a few minutes to cross. But this is also something that's been addressed at the United Nations. We just spoke there last month on this very issue, and they're looking at ways to address it. And the UK online safety bill also has this tenet in there as well to address it on a global level. We're urging legislators at this point to take this seriously in the sense of this is illegal in real life. What we're asking for is that we update what's happening and how the laws protect women, children, minors, and others in real life, and update the laws so they're protecting people online. As we know, online now is just as real as offline. Again, thank you for your time. Thank you for letting us hear from you, and then pass back my time.
Thank you so much, Ms. Ehimi. We will come back to you with questions at the end of this panel. Next, we will hear from Christian Nunez, President of the National Organization for Women.
Thank you very much, Chairperson Pinto and honorable committee members. Thank you for this opportunity to testify in favor of the Flash Act, Bill 25-41, the Forbid Lewd Activity and Sexual Harassment Act. As you stated, I'm Christian F. Nunez, the National President for the National Organization for Women. And just a little history about now, we have been around since 1966, and we are the largest grassroots feminist organization in the United States with over 100,000 of members. And our organization has been around and been driving work advocated on a holistic approach to doing health, safety, and equality for women with the intersectional approach. We have been leading in violence against women through grassroots efforts, helping to convince some of the biggest topics from NFL changing the domestic violence policy. We were the first to ask Harvey Weinstein to be kicked out of Academy for Motion Pictures and Science, and work for Congress on numerous of state legislators to protect women's health and being. So as we're coming, we just want to thank Bumble for the leadership in spearheading and successfully passing legislation on cyber flashing in several states. Cyber flashing is sexual harassment. Cyber flashing is stalking. It is violence against women. Cyber flashing is non-consensual. Receiving a nude photo or other sexual depiction without consent or invitation is a direct invasion of a personal space meant to shock and upset an individual. Cyber flashing really is a rebranded version of the trench coat flasher. It's a shocking and distressing experience. From research surveys, we know that over 50% of young women primarily have experienced receiving a lewd image without their consent, be it airdropped, and this is a continued rising problem. I think we can all imagine, commuting home on a metro or a bus and being out in dark and checking social media or just trying to unwind, and all of a sudden receiving a lewd image on our screen. You can't escape that. You can't get away from that, and not knowing where that is or who that perpetrator is or if they're going to follow you home. That is a very scary and frightening event to occur. And the problem with the cyber flashing is the accountability for holding that person accountable is not occurring. It's dismissed because this harassment is occurring online. And because cyber flashing is upsetting and traumatizing experience for young persons and persons directly impacted, it does have long-term mental health and effects and a sense of personal safety violations and autonomy being impaired. So those impacts can feel scary. They can increase, there is research that says it can increase depression and anxiety and impact the personal feelings of safety and autonomy for those persons. Right now, we're in a place in this world where we're already seeing women feel like their personal autonomy is being directly attacked every single day. So now really does want to urge the council to approve this act. Those who send these indecent images must be stopped, and our local government and federal government must work harder to protect our communities to prevent them from enduring additional harms that can be preventable. The Flash Act can help stop this. Others have taken action. We know that Texas state legislator passed a similar bill with legislators on both party sides supporting these efforts. Transmitting unsolicited lewd images is now a Class C misdemeanor in that state. And we also know that a neighboring state, Virginia, passed a bill unanimously supporting and was signed into law on April 11th this year. And California Governor Gavin Newsom also sent a similar bill. So we know there is support. We know that states want to protect innocent people, women, and their communities from having to endure the harms of this. And we also know that legislation has also been introduced in other states. So we just have to remember that cyber flashing is a form of harassment. It is violent. And there is no monolithic type of consent. It is individual, and we have to remember that. And so DC, we're asking that you do support this because over half your population in DC are women. So we want to make sure that we ask you to support this, and we thank you for this time. And we just encourage you to support the Flash Act. Thank you.
Thank you so much, Eunice. Next and last on this panel, we will hear from Santiago Lacatos, ANC Commissioner from ANC 1B04. Go ahead, Commissioner.
Thank you. Good afternoon, Chairperson Pinto. Thank you for the opportunity to testify today. My name is Santiago Lacatos. Like you said, I'm an ANC Commissioner in Ward 1. But in my professional capacity, I work in social media trust and safety, protecting online users from abuse. My testimony today is on my own behalf and doesn't represent the views of my employer. I'm testifying today in support of the Flash Act, and like Ms. Lent mentioned, sort of like many people with a cell phone who had AirDrop on or has had their cell phone number posted publicly, I've also been the victim of cyber flashing. But I'm also well aware that I'm not amongst the most targeted group by cyber flashing, as it disproportionately affects women. The council needs to recognize and prohibit these emerging forms of harassment enabled by widespread technological adoption. This legislation is needed to convey that such non-consensual behavior is unacceptable. And so as we are discussing this specific tech-enabled sexual harm, I wanted to raise another emerging tech-enabled abuse that's also in need of urgent regulation, which is AI-generated non-consensual exploitative imagery, or what is sometimes referred to as deepfake pornography. So as you might be familiar, the monumental advances in generative AI image diffusion models and their distributed access means that novel forms of abuse, such as AI-generated NCEI, are growing in proliferation. While this can enable a lot of really creative uses and has a lot of legal and legitimate purposes, it has also allowed abusive actors to inflict immense harm on individuals by creating photorealistic, synthetic nude, revealing, or sexually exploitative images without consent. So AI-generated NCEI includes synthetically undressing a person from a photo posted of them, such like an Instagram photo or a photo in a dating bio, swapping someone's face onto a nude image in a photorealistic manner, or a video as well, or entirely creating an image from an AI model by using a person's face and features and adding sexual context to the photo, to name a few. Some websites and online chat groups work specifically to develop and sell this form of abuse as a service to individuals without the know-how. So think of it sort of as an abuse for hire. It's been used to harass public figures, journalists, actors, celebrities, as well as kind of just unwitting individuals who had posted an Instagram photo and had no idea that someone would be taking that and using it to create sexual content. So right now, creating AI-generated NCEI isn't illegal in the District of Columbia. It's actually only illegal in 3 states, California, Virginia, and New York. And while government regulation lags behind the pace of technological abuse, part of the reason for this hearing today, given the unprecedented speed of AI image development and synthetic NCEI, we really can't wait to address this problem. And I'm hoping that the committee can consider prohibiting this type of abuse, either as an addition to the Flash Act or sort of through standalone legislation to follow, beyond the need to just address harm to district residents. Explicitly targeting this AI-generated abuse and prohibiting that practice sets a precedent for other jurisdictions to do the same. This could include actions such as adding AI-generated NCI to the district's revenge porn statute, creating a similar private right of action, or authorizing the Attorney General to act against vendors who provide this type of abuse as a service. So thank you for the opportunity to testify today, and I'm happy to answer any questions you might have.
Great. Thank you all so much. Really appreciate your testimony. I want to start with you, Ms. Nunez. If this bill passes, I think a big piece that we need to stay focused on is education and making sure that everybody knows what the laws and protections are that they have. How do you think, or how have you seen more effective in other jurisdictions governments go about educating the public about the law and ensuring that women, in particular with fewer financial resources, can also more readily pursue legal action if their rights are violated?
Yes, thank you, Chairwoman Pinto. I think this is important where you can utilize your advocacy organizations to make sure that there is access to this information about this act and what their rights are, and just really reaching out to communities that are there to provide services and resources, making sure they're explaining it in very digestible terms, explaining what those rights are, what everything is, breaking it down, very digestible terms, and explaining those rights to them, so they understand what it means, understand what their rights are, what they can do, who they can go to, how they can process their rights and things like that. This is where organizations like myself, NAAPC, different community centers, women's groups can be very effective in helping communicate these rights and helping those who've been impacted utilize these services, and also make sure they're just advocating on behalf of themselves.
Okay, thank you very much. And thank you for all of the work that you do.
Thank you.
Commissioner Lakatos, are you aware of any other states or jurisdictions that have taken similar action to combat non-consensual deepfake pornography? And a sense of how common this problem is?
There are 3 states that have taken steps. So New York and California have prohibited deepfakes broadly, and they created sort of a civil private right of action, and they included sexual deepfakes within those. But I think that reading the text of those legislations is not targeted enough, I think, at the way that the abuse is developed online. Virginia had just added it to their revenge porn statute, so they included it as sort of, or like images, shared without consent or like generated. I'm not sure how prevalent it is. I can tell you that I've come across, groups that operate in like on the dark web or in like Discord groups or sort of on chat rooms and websites that sell this and sort of teach people how to do this. And I can't count how many people are doing that, but I can tell you that it's not a technologically challenging thing to do, that you would normally need a lot of resources, versus now you can type words into an application and put an image somewhere and it can actually create something that's photorealistic.
Got it. Okay. I'm just thinking about, like, in the context of this bill that creates a private right of action, because some of these images are so distorted that it likely is even harder to tell who the perpetrator is of creating these images, which I think is part of the problem here.
Yeah, no, there's no easy answer, but I felt it's worth using a venue like this to kind of bring this as a starting point. It might not necessarily fit perfectly in this bill. Obviously, that's up to you and the committee members, but it's a challenging form of law that I think we're going to have to figure out.
Okay, well, thank you so much. No, I really appreciate you raising it, and I think it's another example of, in this technological age and with the proliferation of folks communicating on the internet, there's not necessarily a perfect fit for some of our current laws that govern our in-person behavior, which is what part of the Flash Act seeks to rectify. That if we have already outlawed indecent exposure, and I hope we would all agree that somebody couldn't indecently expose themselves to you without consent, and that's what this is seeking to rectify. So I want to ask you, Ms. Sultan, about some of what you talked about with your concerns with the bill. I guess just as a starting point, you shared that you have some concerns about the language being too overly broad. I don't see the example that you provided fitting in here, because this is really about being non-consensual, and that's kind of how we sought to structure it. But do you have other language changes that you think would make this better aligned with the goal that we're trying to accomplish here?
The bill does not use the language non-consensual. It says unsolicited, which is remarkably different. Unsolicited is not defined, and most people would understand that to mean you have to solicit the image, you have to ask for it, you have to request it in advance. We spent an awful lot of time writing out a definition of effective consent for the revised criminal code. There is language about consent in the Texas bill and the Virginia bill. Those are not defined either and are going to be subject to litigation. I will be shocked if either of those bills, isn't struck down very quickly, but supposing that they aren't, they're better written than what we have here. We also already have a private right of action for everything that's been described this afternoon. You can sue someone for intentional infliction of emotional distress. You can sue someone for doing it negligently. You can sue someone for for defaming you, for making a fake picture of you. We already have a right of action. What you're doing here is creating a statutory minimum, which is the statutory maximum in Virginia, not an identical penalty as it was described in your opening statement, for every image that's sent, every person that receives it, every follower of Beyonce on Instagram, every person who's ever seen an image like this transmitted to their phone. I mean, this could be trillions of dollars the way you've drafted the statute. It's unnecessary and it's unfair. There hasn't been an example given so far that this would create a new cause of action for. And what you're doing instead is putting people in jeopardy, particularly victims of serious sex abuse offenses who may have used sex classified websites in the course of their abuse, and giving them a reason that they cannot report those really serious violent crimes. And so I don't think that this is the solution that you want to tailor, but if you do want to tailor it, you can look at the 200 pages of recommendations that I wrote while I was at the Criminal Code Reform Commission that explain how you do this using the right mental states, how you confine it to what's not constitutionally protected speech, how you make sure there are exclusions for people who need to forward a picture to law enforcement, for example. None of that is included in this bill. It's really, really poorly done.
Well, thank you for those ideas. And I would say that's exactly what we're here to do today, is have a hearing on this bill and figure out how we can make sure that it's well crafted. So if there are, additional definitions to make things more clearly, especially around consent, I am certainly very open-minded to that. I think the bar for demonstrating that there has been intentional infliction of emotional distress is a very high bar to meet. And with a lot of these cases that we're seeing, especially in public settings that many of our witnesses talked about, in libraries or on transit, those cases have been very hard to prove. And it's important to me to make sure that this behavior that is disproportionately targeted to women is very clear that it is not acceptable, and has its own standalone offense. We did see that you and the commission included language around it in the revision recommendations, which I really appreciate. And I am surprised to hear you so opposed to it, because I share the frustration that the commission and the recommendations are kind of we're halted and we're disapproved by Congress, and we're going to have to continue working on that. But in the meantime, I don't want victims of these crimes to suffer by continuing to have to wait for a private right of action. I certainly cast no judgment on what consenting adults do and send one another, but I do take issue with non-consensual victimization of women, and that's what we're trying to rectify.
Each of the examples I've given you are examples of non-consensual texting. If I take a video at a strip club and send it to my friends who were at the strip club with me without their consent, that would be a violation of this statute, even though it is not an infringement on anybody's privacy right, liberty interest, or offensive to the person who's receiving it. All of the artistic examples that are listed in my written testimony, including the Super Bowl halftime show that included sexual contact between someone's hand and someone's breast, would be a violation of this statute. If you sent that video to somebody and said, oh my gosh, look at Janet Jackson, now you've committed the offense because they didn't ask you for that video of the halftime show before you sent it to them. There's a lot of artistic, scientific, and other expression that you are now restricting. And people are not going to ask permission before they send these very commonplace, mainstream kinds of content, from a romance novel cover to a magazine cover with Kim Kardashian's buttocks showing. All of those things are banned by the way you wrote this, and changing the definition of consent does not fix that at all. It doesn't fix the statute. It should be voted down.
I guess I would say there's a difference between banning something and empowering somebody to bring a case if they were personally victimized. And that is not present in the examples of friends sending each other images of, a halftime show that was televised. And so I'm happy to keep thinking through the language to make sure that we are being careful and not overly broad. But I still do believe that the non-consensual activity that far too many women and people are being victimized by is not acceptable. And that's what we're seeking to fix here. I do want to turn to Peyton Hemi and ask you a little bit more about what you're seeing at Bumble, and if there are current options that you've seen, if any, that your users have to hold perpetrators of cyber flashing accountable.
Yes, thanks for the time. I can address a few points. I do agree the AI issue is troubling. NCI and AI are very troubling. We work on that issue as well, but we do keep it separate because it needs a different type of review, and we do keep that work separate from this type of cyber flashing, but it is a growing and it will be next gen epidemic. So agree with the council of keeping it separate, but also agree with why it was flagged to begin with. The other thing I'd like to flag is free speech doesn't protect harmful speech. And this is a private right of action. It provides the opportunity for the adjudication of what occurred in the texting and the behavior that was there, versus this being a different type of ruling where any image is seen as an issue. And so the other thing I wanted to flag too is we've been meeting with advocates, victim advocates, and are in many consortiums and new ones created. This is a growing call to action. It's a global growing call to action of people trying to police the internet and finding ways to try to police the internet. It's a little bit wild west out there. We only focus on 18 and above specifically for a reason, but there's a reason why there's already protections against this type of things for 18 and under. Right? And that's federal protections. There's a reason for that. So we understand that there could be instances where there's these challenges, but again, that's why it is in a procedure. That's why it is in a private right of action to allow those to go on. But it's only increasing. During COVID, we saw it explode. I can't really answer why people felt with their spare time that this is what they wanted to do when there was economic and health crises, but it was the harassment of women at large, especially even public-facing women, that was an issue. But we're here representing regular victims, no one famous. And that's kind of who we hear from and who is a lot of our users are the everyday women who aren't able to be on a testimony like this or on public stage or, public office that this is happening to or suffering in silence.
Yeah, thank you. Donna Lent, how does online sexual harassment impact the women who you support who are running for office?
Well, first of all, it is something that happens, especially not always. I mean, it's used as a weapon for women running for office. They don't know where it's coming from, but the goal is to completely unsettle them, take them off their mark. Getting an image such as this before you're walking into a meet the candidates night or a civic meeting, it really does rattle a person. And you don't know if that person is in the audience. And when you think about the political discourse that's been taking place over the last few years, I mean, it just really does become a sense of danger for women. They don't know what's to come after that image. They don't know, and they certainly are not out there. They're not in the marketplace. They're not out there on the dating scene. These are people that are just trying to live their lives and accomplish the next step in their careers. And it seems very often that once if you are targeted in a political realm, it goes back to this, it's sexual in nature. This is how they are really attacking your beliefs and trying to chase you from the political landscape.
Yeah, well, thank you very much for sharing that. And I think it is far too common. how we continue to see this happen. I want to ask you, I know we talked about, Peyton, how this is an issue that is far beyond just on dating apps, but for those instances that do arise on dating apps, if Bumble or other competitors that you've seen in the industry will have a standard on how to determine who the perpetrator is with their full identity, if a cause of action is pursued.
Yeah, absolutely. There's anonymous apps, much more difficult, but you wouldn't be able to bring a case because you need to know who sent it to bring a case. So out of scope, right? But once you do know who the victim is, and believe me, they are very emboldened. They're doing this, again, I'm not naming names, but they're doing this on business networking sites. Their entire resume is there. That's how emboldened they feel. A lot of apps have a by name just by the nature and the ruling of the app. Very easy. On ours, we will know and we'll take it down, right? That's our statement of work. Different technology companies might have different standards. And then also to victims, this goes back to what now and NWP were saying, there's no rules. So they just feel, that there's nothing that they can do. They never even bring it to the app provider or the technology person or even their place of work because they don't actually realize that there's any rule against it. I should note that, we created Bump Private Detector years ago, but last year we open sourced it. There was no financial gain for us from that. We open sourced it. We're working now to even open source that at a different level at the UN. We want the technology to get out there, but I just can't emphasize more. And technology can't outrun bad actors. If we're not stemming the flow of the activity, we're never going to keep up. We're going to be consistently trying to Frankenstein. And when I say we, I don't mean tech company, I mean our whole society. We're going to be trying to Frankenstein some kind of solution. You can't outrun bad actors. You need to have a deterrent and you need to have precedents and set some ground rules that it's not the norm. Think about the generations coming up. There are some generations that are like, this is normal activity. They can't understand a green flag from a red flag and leading into domestic violence, domestic abuse, et cetera. And so there's been norming that's been happening and acceptance of this and hiding behind, false flags of, free speech, et cetera. And this is one that's more clear cut. We're using the example of what happens in real life and why it took so long for it to even be rolled out in real life. Victim blaming, what were you wearing? Why were you there? Why were you out so late? That was in our generations and our mothers' generations. We don't need to take 20 or 30 years to start cleaning up the internet because we don't have the time. The proliferation on the internet is going to outpace what we saw in the real world. And it took some time there. In 2 or 3 years, we're already at a point where we can't put the genie back in the box.
Yeah. Okay. Well, thank you very much. I want to thank all of our public witnesses for sharing your thoughts today. I really appreciate it on this important bill. Thank you. We are now going to call our government witness, Janu Park, who's the Executive Director of the Criminal Code Reform Commission. And as you know, it is the tradition of this committee to swear in all government witnesses who appear before it. So when you're ready, if you could take yourself off mute and raise your right hand. Do you swear or affirm under penalty of law? I'm sorry, excuse me one moment. Okay. Do you swear or affirm under penalty of law that the testimony you are about to provide before the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
I do.
Great. Director Park, please go ahead. With any open.
Thank you.
Testimony.
Sure. Well, thank you, Chairperson Pinto, for allowing me to testify today on behalf of the CCRC. And I'll be testifying today just again regards to the bill B25-41, known as the Flash Act, but I will not be testifying with regards to B25-51, the Crime Victimization Survey Act. First, I recognize that the Flash Act creates a civil cause of action, and normally the CCRC would provide advice and feedback on criminal legislation. But the CCRC had produced a similar criminal offense called distribution of obscene image as part of the revised Criminal Code Act. And it's just based on our research and recommendations on that offense. We have some comments and feedback on the civil action that would be created under the Flash Act. I also want to note that the CCRC takes no position as to the Flash Act, as to whether or not civil action ought to be created or what the proper scope of that civil action ought to be. So instead, our testimony is really just going to identify some of the legal issues and ambiguities that may inform the committee as it proceeds with this bill. So our testimony today is going to really cover possible First Amendment issues, as well as some issues relating about definitions and ambiguities as to the scope of the offense or the tort that could be clarified moving forward. First, as some other witnesses have already mentioned, as currently drafted, the Flash Act may violate First Amendment free speech protections. So the right to free speech, of course, has limits. The Supreme Court has held that certain types of speech are subject to regulation. Here, most relevantly, we're talking about obscenity. Now, what constitutes obscene is famously hard to define. But in the case of Miller v. California, the Supreme Court established a three-part test known as the Miller test to determine whether content is obscene. So first, an average person applying contemporary community standards would have to find that the work appeals to the prurient interest. Second, courts look to work whether the work depicts or describes sexual matters or sexual conduct in a patently offensive way. And then finally, they would ask whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. So this isn't a crystal clear line, but it is clear that not all sexual imagery or nude imagery necessarily constitutes obscenity under First Amendment case law. Should note also that the Miller case dealt with a criminal offense, but the Supreme Court did recognize in a case, New York Times Company v. Sullivan, that even in the civil context, by relying on the power of the courts, the state's power is invoked, which then triggers First Amendment protections. And this is especially true in the case of tort actions as opposed to contractual or property disputes. Now, the Sullivan case dealt with a libel action. In our research, we're not familiar with any cases that specifically address the kind of civil action that would be created under the Flash Act. That's probably due to the fact that this is a fairly novel piece of legislation. However, though, given the fact that this is creating a civil action which directly targets speech based on its content, it does seem very likely that this would implicate the First Amendment and trigger the kinds of free speech protections that we typically see. So the Flash Act does define this term obscene image, but the definition nor the rest of the elements of the civil action actually require that the three-part Miller test be satisfied. So it does appear, and some of the definitions are a little bit unclear, but it does appear that the civil action would reach constitutionally protected speech. So for example, the term obscene image in this bill includes an image that depicts a real or fictitious person engaging in sexual context or sexual acts. Now, those terms, sexual context, sexual act, are undefined in the bill, but presumably it could include an image or a video of a simulated love scene from a film, or an image of a person just happens to be touching someone's rear end. That's the type of speech that typically would not be found to be obscene under the Miller test. In contrast, like I said, the RCCA did have an offense, distribution of obscene image. That offense actually, amongst other elements, requires that the image that's being distributed satisfies that three-part Miller test. So in the sense that the constitutionality of the criminal offense is ensured by requiring as an element that imagery is obscene under the Supreme Court's test. Should note, even to the extent that any law regulates non-obscene imagery in a content-based way, it's typically subject to strict scrutiny analysis. And that would require the government is pursuing a compelling interest and that the law in question is narrowly tailored. There have been instances of laws that are regulating non-obscene materials still passing constitutional muster under strict scrutiny, but it's a very, very exacting standard. And depending on the exact scope of the kinds of materials that are covered under this draft bill, it's unclear, at least from our vantage point, whether or not this bill would pass strict scrutiny if it were actually challenged in court. Moving on from free speech concerns, I just want to address some ambiguities that we identified under the Flash Act. So first, the action doesn't specify any mental states. It just creates a civil action for transmitting an unsolicited obscene image by electronic means. Now, torts don't necessarily have the exact same kind of mental states that we see in criminal offenses, but they typically do require some kind of wrongful state of mind, whether it's intentional infliction of emotional distress or something like mere negligence for damage to property. There is a provision in this bill that creates a presumption of knowledge when an obscene transmission was made. So this strongly implies that something like a knowingly mental state is required, at least as to the transmission of that image in the first place. Knowingly isn't defined in the bill, and also it's unclear if there's any or what mental state or any would apply to the other elements of the tort. So for example, let's say someone does knowingly send an image to another person, but they don't fully realize that the image contains this kind of obscene material. Or they may believe wrongly that the other person had requested or consented to receiving that kind of material. It's unclear under the way the bill is drafted whether that person in that hypothetical case would still be civilly liable for the tort. And so it's possible, again, I don't know the exact scope of the tort that the committee was really intended to create here, but potentially some redrafting could define that scope to be either narrower or broader based on the intent of the committee here. Second, there's a lot of terms that are left undefined. So again, the Act does define the term obscene image, but as far as I understand, no other terms are defined, including terms that are used within the definition of obscene image. I just want to touch on a few notable examples here. So one, the term unsolicited is undefined. So the Flash Act creates liability when someone transmits an image unsolicited. Under the analogous RCCA offense, we require that the defendant acted knowing that they lacked effective consent. So consent is a defined term under the RCCA. It's defined as a word or act that indicates agreement, either implicitly or explicitly, some kind of conduct or some kind of result. So that's actually an affirmative consent rule, but even just an act that implicitly suggests agreement would be enough. So for example, if someone sends an obscene image to their romantic partner, and based on prior acts or prior conversations, they think that implicitly their partner agreed to receive that kind of obscene imagery, they would not be guilty of the criminal offense because they wouldn't know that they lack that consent. But the term unsolicited is undefined, and it could be interpreted to mean the exact same thing as lacking consent under the RCCA, but not necessarily. The term solicit is often used to mean to ask for something or to request something. So in that hypothetical case, even if a person really believed that based on prior acts, their romantic partner was really willing to receive this kind of obscene imagery, it's possible that if they didn't explicitly request it, that they could still be guilty or found liable for this offense because they sent the image unsolicited. And again, it sounds as if based on the conversations that you and other witnesses have been having, that the intent was something a little bit closer to what content as it was defined under the RCCA. It's not clear to me. But then I think that the committee could probably maybe amend the language, define terms a little further, maybe include language even in commentary that would accompany this bill that would really clarify exactly what the committee wants to cover when it uses that term unsolicited, so that the defense isn't overbroad to include cases where we don't really want to have civil liability. Second, the term image is undefined. Presumably that includes photographs, including digital photography. But it's unclear if it includes things like videos or 3D holographic images, because who knows what smartphones may be capable of 10 years from now. So again, it's not, I don't know exactly the scope of liability that the committee intended here, but it could be helpful to define a term like image. So if the committee wants, for example, videos to also be included, that it's very clear on the face of the statute that those are also included for liability. Finally, the terms sexual act and sexual contact are not defined. So given that they're not defined, I think it would be reasonable for a court to look to definitions of those terms that are found elsewhere in the current code. And if they do that, then potentially this is a pretty broad tort. So for example, sexual contact has been defined elsewhere in the code as the touching with any object, either directly or through the clothing of genitalia, anus, groin, breast, inner thigh, or buttocks of any person with intent to sexually gratify the desire of any person. So again, this could be just a picture of someone squeezing someone in the rear end, even consensually would constitute a sexual contact. Sending an image of that to a person unsolicited would constitute a tort, the way that this bill is drafted. Now, as I talked about earlier, I think that would likely be an unconstitutional application of the statute. If an obscenity requirement were added to this, sort of codifying the Miller requirements, I think that would just sort of categorically rule out a lot of these less egregious types of sexual acts and sexual contacts. But regardless, it could be helpful just to guide courts to have some kind of definitions for these, so that it's just a little bit clear about what kind of images that we're really talking about that would trigger the liability under this act. And then finally, I just want to touch a little bit on some of the exclusions. So the Flash Act does include some exceptions to liability, including when images are sent for legitimate medical purposes. Again, if a sort of a Miller test is included as an element of the tort, I think that legitimate medical purpose exception is likely redundant. Again, remember, one of the prongs of Miller test is that the imagery is patently offensive and lacks any serious scientific value. Virtually any kind of image sent for legitimate medical purposes would categorically not be obscene. Secondly, there's some exceptions that we included in the RCCA analogous offense that are not included here. So for example, sending obscene images to law enforcement to report potential illegal activity, or sending it to an attorney to seek legal counsel are accepted from those criminal offenses. And potentially, civil lawsuits are relatively unlikely in that context, but the committee may want to consider some additional exclusions to tort liability just in case, so that people aren't wrongfully ensnared and required to pay the statutory penalties authorized under this bill. So to wrap it up, again, the CSRC doesn't take any position on this act or any of the specific issues that we've identified here today. Just wanted to highlight some of them for the committee as they move forward with this bill. I do want to note we will be submitting a more detailed and more thorough written statement. I unfortunately was out of the country and some other staff was out of the country last week. We didn't have time to wrap that up, but we do intend to provide that on the record for the committee. We're happy to work with the committee moving forward if they want any kind of advice or guidance on how to address some of these issues. And lastly, again, myself and another staffer were out all last week. So I do want to thank two of our attorneys, Rachel Redford and David Richter, who really did a lot of the heavy lifting in terms of the research and analysis to help prepare the testimony today. And so I just look forward to any questions that you may have.
Great. Well, thank you so much, Director Park, and to your team. I certainly will take you up on that. We would love to work with you all to make some of these tweaks and ensure that the language is tailored to what we're trying to accomplish and what we're trying to remedy here. I am curious though about your arguments about Miller, and I'm trying to reconcile, on the one hand, when you talk about the definition of obscene, you suggest that we may want to be more clear to lay out that the Miller test is still embedded in it, whereas of course it's embedded in theory because it's preempted by anything that the Supreme Court has already ruled. But then on the other hand, you suggest that it's redundant to include exceptions that are delineated because they're already accounted for in Miller. So how do you reconcile these 2 points?
Yes, I meant were the committee to add and codify the Miller requirements. I think that medical exception would very likely be redundant. It wouldn't hurt to leave it in, but if those were included as express elements of the tort, then yes, I think that would probably be redundant. I would say though, it's just, unless I misunderstood, it's not implicitly required. That is, it is possible for legislatures to pass laws regulating speech that is not obscene. It just typically, if it's a content-based regulation, it just triggers strict scrutiny. And there have been examples. I think there was talk earlier about revenge porn statutes, which are also fairly recent. There have been First Amendment challenges to those as well. At the state level, I don't believe it's reached the Supreme Court as of yet. I think we won't heard about that. So it was just last year, for example, in Indiana, there was a First Amendment challenge to Indiana's revenge porn statute. They argued that revenge porn should be a new category like obscenity of non-fully protected speech under at least Indiana's free speech provision under their state constitution. And in that case, the Indiana Supreme Court declined to take that reasoning, but did say even applying strict scrutiny, they found that there was a compelling interest and that revenge porn statute was narrowly tailored. So in theory, it is possible, even if some of the kind of imagery that the committee wants to really target here, even if it doesn't meet the Miller standard, it's possible that it can still be regulated under a new tort, provided that it meets strict scrutiny. But I really can't say how that would really play out of courts, especially given it's such a novel area of the law, and there really isn't clear precedent yet as to how those cases will be resolved.
Gotcha. Okay, thank you for that. And then I'm just curious if you can elaborate a little bit more on how you would advise we define consent.
So some of it depends, again, on the exact scope of conduct that the committee really wants to capture. I do think, based on the conversations that the other witnesses have been having, that a definition very close or identical to what we codified in the RCCA would work here. So again, it's an affirmative consent rule. It just requires some words or actions that even implicitly indicate an agreement to a certain outcome. In the cases here where someone is just airdropping, an explicit photo to someone, clearly, even the way the RCC has defined this consent rule, that would be acting without consent. Similarly, I think in most of the cases, again, this would be a fact-based determination, but most of the cases of, when someone's on a dating service, maybe they have an initial contact with someone and then they send a nude photo or sexually explicit photo. Unless the person really gave some words expressing their agreement to receive those kinds of photos, it would probably be without consent as well. So I think something like the RCCA would probably capture much of the kind of conduct that it sounds like the committee wants to capture without going overly broad. So in the case of, again, the romantic partners where someone's wife has said something that suggests that she's really agrees with this, she doesn't affirmatively solicit those images, there would be no criminal or tort liability. But again, that's really a policy decision about the breadth of the liability that the committee really wants here.
Okay. Well, thank you very much. And as I said, I would love to continue working with you to make sure that this is well defined and clear. Of course,
sure.
Courts will interpret some of this, but we want to do our best to make sure that it's as clear as possible and aligned with our intent. So thank you, Director. Thanks for your testimony.
No problem. Sure. Yeah, feel free, of course, to reach out if you have further questions or want to work with this moving forward.
Great. Thank you. All right. We will now turn to our final panel of public witnesses to discuss the District of Columbia Crime Victimization Survey Act of 2023. We will hear from Michaela Deming from the DC Coalition Against Domestic Violence and Lynn Addington, public witness. Great. And Michaela, whenever you're ready, please go ahead.
Sorry, I missed the invitation once I was clicking over. My apologies. Good afternoon. My name is Michaela Deming. I'm the Policy Director of the DC Coalition Against Domestic Violence. We're the federally recognized state coalition of domestic violence service providers here in the district. Intimate partner violence continues to be a significant safety and public health concern for DC residents of all ages. And the dedicated service providers, of which I represent, we have 18 member programs, work tirelessly to address the epidemic of domestic violence across all 8 wards of the district. This testimony will be familiar. I know that you reviewed the December 8th testimony, so I will review the highlights of the suggestions that we have. We are grateful for the council's support of our member programs, and we support the council's commitment to collecting and analyzing data to inform violence interventions and victim services through a survey. Our member programs recognize the need for additional data to really show the range of needs that survivors have and how well we as a district are able to meet those needs. The data, if collected in collaboration with our service providers, can really provide key information to our understanding of domestic violence, other victimization types as well, and the response efforts in the district. In an effort to strengthen the bill, we have 3 potential changes that we'd like to suggest that would further the impact and the benefits of the survey. The first one has to do with the consultation with survivors and advocates. We would like to urge the council to meaningfully include survivors' expertise in the development and the analysis with the appropriate compensation for their expertise. And we know that domestic violence survivors provide a critical and unique perspective as particularly vulnerable crime victims. And other state and national crime victim surveys have recognized this importance and have employed their expertise. We also ask you to consider actively involving both those survivors as well as victim advocates. In our case, specifically, domestic violence victim advocates have insight into the landscape of system-based services, such as law enforcement, court-related remedies, limitations, barriers, and non-systems-based safety-seeking behavior of the clients we serve. Our member programs have decades of experience serving survivors and helping them navigate safety and healing. This historical perspective informs what information and data has been available and what is still needed to be gathered to supplement and best support service providers. Second one has to do with requiring survey expertise in diversity and inclusion. We would ask that the surveying entity be able to demonstrate expertise in diversity and inclusion. I know you mentioned this at the start, having to do with language accessibility, but also really being able to accurately survey victims of crime. I believe that you heard from one of our member programs, DVRP, which raised that the majority of their clients are non-English speaking or non-English language proficient, and without adequate consideration, meaningful language access, as well as outreach to the community, there won't be reliable data collected from those communities that are already most marginalized. The third thing we had to suggest has to do with identifying a new source of funding. As we've been going through this budget process, that our member programs are already stretched to their financial limits in attempting to serve the increased rate of domestic violence victimization in the district during the pandemic and continuing today. And so diverting any of those existing resources for the purpose of collecting data would jeopardize our efforts. And so we would ask that if this act moves forward, that there be a new source of funding that does not detract from funding that is currently spent on victim services to support this. So in conclusion, we greatly appreciate Council's commitment to addressing crime victimization in the district. We ask that you consider our suggestions and look forward to continuing to work with district leaders across the governmental agencies to end domestic violence and all forms of oppression. I'm available to answer any questions, and thank you, Chairperson Pinto, for the opportunity to testify this afternoon.
Thank you so much, Ms. Deming. Next, we will hear from Lynn Addington, public witness.
Great, thank you very much. Some of this will be the same since I was asked to basically reiterate my testimony from December. But good afternoon. My name is Lynn Addington. I'm a criminologist and a professor in the Department of Justice Law and Society, or Justice Law and Criminology, I should say, at American University. And I've worked with crime victimization surveys for almost 25 years now. I strongly support the idea of a DC crime victimization survey. Surveys can be a valuable tool to get input from citizens, especially victims of crime, to inform policies addressing the accountability of the criminal justice system, support for crime victims, and residents' perceptions of safety. Other jurisdictions have seen the need to invest in these data. Since 2000, 15 states have sponsored their own crime victimization surveys. And crime and victimization surveys are an investment. To get the greatest return on this investment, care is needed to clearly define the goals of the survey and to design it to serve these goals. Without this initial process, the value of the survey is greatly diminished, as it will try to serve many functions and not serve many of those very well. The current bill suggests an interest in 3 goals: estimating the amount of crime in DC, responses to crime by victims, and citizens' attitudes about crime. Any one of these goals could encompass an entire crime victimization survey. So it's helpful to consider how the information from each goal might be used and whether the council has a priority with a specific goal. A survey with the goal of enumeration would provide estimates about the amount of crime in DC. Depending on the types of crimes collected, these data could be compared to or supplement police data. One caveat with this goal is that generating reliable estimates of crime can be very expensive. A survey that focuses on responses to victimization highlights the unique contribution of crime surveys, as they can measure the impact of criminal victimization in ways that police data cannot. This information could include the cost of victimization in terms of economic and psychic harms, as well as victim responses such as reporting to the police, disclosure to others, experiences with the criminal justice system, and use of victim services. These data could inform victim-centered policies, but one caveat is to limit the potential burden on individuals who are recent victims of crime. And the third goal focuses on public attitudes and perceptions about crime. This type of survey has a unique strength, including the fact that all respondents can answer the questions to the survey, as opposed to only crime victims. Information about perceptions also is important, as these play a powerful role in how safe victims feel, as well as their views of crime prevention efforts and criminal justice officials. And policies should consider perceptions about crime. For example, perceived risk and fear can limit activities and engagement in the community. I know I'm about out of time. I'd be happy to talk about design issues, especially a potential advisory board for creating this crime survey. But for now, I'll just leave it that I'm very much in support of the crime survey. Thank you.
Great. Thanks so much, Ms. Addington. That's really helpful. I like that idea. I want to start with you, Ms. Deming, and just, I think that this importance of including survivors in the survey development process is a really important idea and point. Can you elaborate a little bit more on what you think that should look like in practice? How many survivors should be included? What should their involvement look like? Do you have a sense of how many different types of crimes we should be thinking about in the creation of the survey and in the analysis process?
Yeah, I think these are all great questions, and the answer, I think, depends on how everything else gets structured. If there is some sort of advisory board, if there is, a group of researchers and a group of advocates in the community, or government folks and community folks and survivors, or a separate group of survivors that are informing. I think there's a lot of ways that it can work. I think it's just important that survivors aren't added as a token to the process of creation and collection and analyzing the data, but that they're really an integral part and treated as the experts that they are in their victimization.
Got it. Fair enough. Thank you. And in terms of responsibility over this survey, do you think it makes more sense to be housed in OVSJG or CJCC?
I'm not sure what makes the most sense. I can tell you, and I didn't mention this in my testimony, but I can tell you that one of our federal funders, FIPSA, the Family Violence Prevention Services Act dollars that come into the district, have a new requirement for a state needs assessment, statewide needs assessment and state plan. And so that is something that is getting underway. It is in every state that gets the FIPSA dollars. And that might be something that makes sense to pair with this, or to make sure that this can help contribute to. So it might make sense to pair it with the funding source, or how it's directed through the district there.
Interesting. Okay. Gotcha. And Ms. Addington, how frequently do you think that this type of survey should be conducted, or do you have a sense of how other jurisdictions do it?
Well, the most familiar one is the National Crime Victimization Survey, and that's one of our 2 national measures of crime. That's in the field people are interviewed every 6 months, because you're balancing the idea of memory issues with regard, we remember things are much closer in time, but then we also have to balance those with sample issues, right? So if we could get everyone what you thought of yesterday, but we need a huge sample to get crime victims, right? So, so the federal government does that with a 6-month reference period. Most states, I believe, use a 12-month reference period, because they're balancing cost issues. obviously, the more you're in the field, the larger the sample, the greater the costs that are going on. And also, when we're talking about the district, it's also, when we're talking about the nation, it's a larger sample and that sort of thing. But so I would say probably like 12, I use a 12-month reference period is seen as the kind of the longest you'd want to do that. I believe the bill is talking about every other year for the survey. So again, some of it depends on what the purposes are. So if the purposes are perceptions of crime, that might be something that you could have kind of cycle questions through, and maybe have different, kind of modules that you use. If you're looking for akin to the NCVS, the National Crime Victimization Survey, and you're looking for actual enumeration of crime in the district, then that might be something you want to do more, more frequently. So it kind of depends on the purpose of the survey and what the council wants out of that as to the frequency of it. But again, to kind of go, I kind of teased a little bit with the advisory board, but to the extent that you have a set of experts, and these could be, and I appreciate the, Michaela, I think we were together in December, but again, the importance of victim survivors and advocates, and bringing a lot of people to the table. So when I'm talking about advisory board, I'm not prioritizing researchers as the only people who would be at the table. I think that you would want a group, and especially given the diversity of DC, you'd want diverse voices from, if you're looking at surveying people and across the wards, then you would want to have voices about, kind of the groups across different wards and, representation onto how best to reach them and what the council wants out of this. So I'd say that would also be a resource for the council to best shape the survey.
Interesting. Okay, and those voices, those diverse voices could in theory make up the task force to determine that how we move forward. Interesting. Okay. Well, thank you both very much. We will definitely be following up as we kind of move forward on this to make sure that we get this right, and that this information is inclusive and supports our efforts to support survivors and victims, and make sure that we're accurately collecting this information, which, as you all know, is sometimes really hard to get, and especially when not everybody's come forward for a whole host of reasons. We want to make sure that we're supporting them thoughtfully and that we're getting an accurate depiction of the current state of affairs. So thank you both for your work here.
Yeah, I just one quick moment. I'm sorry,
Sure.
I don't mean to take up more of your time, but also the not to discount the perceptions of citizens, because you hear, I hear in the news, and I'm sure you hear much more being a council member, about the perceptions of fear in neighborhoods and the perceptions of crime in the district. And that's such a powerful, to get a better read on that. And that's something where a survey really could provide that unique insight to gain information from victims and survivors is very important, but also the average citizen who might feel fearful to go outside, to be engaged with the community, to do all the wonderful things that the council is promoting and creating in the district. And if people don't feel comfortable and safe to do that, that's a real challenge. So to the extent that we can include those perspectives, I think that's important as well.
Thank you so much. I can't think of a better closing than that. So thank you very much, Addington and Ms. Deming, and thank you to all of our witnesses today for testifying on both of these bills. And I look forward to working with you all as we move forward to try to get both of these issues right, and keep moving in the right direction. So appreciate you all being here. And with that, the time is now 3:31 p.m.